Professor. I'm Hannah J. Damoste from Group 3, and our group will be discussing about the incentives for employers hiring PWDs. So the question is, what are the incentives for employers hiring PWDs? It states here that private entities that employ disabled persons who meet the required skills or qualifications, either as regular employee, apprentice, or earner, shall be entitled to an additional deduction from their gross income equivalent to 25% of total amount paid as salaries and wages to the disabled persons. However, that such entities present proof as certified by the DOLE that disabled persons are under their employ. Provided further that the disabled employee is accredited with the DOLE and the Department of Health as to his disability skills and qualifications. Private entities that improve or modify their physical facilities in order to provide reasonable accommodation for disabled persons shall also be entitled to an additional deduction from the next taxable income equivalent to 50% of the direct cost of the improvements or modifications. To give you an example, before hiring PWD employees, taxable income is 1 million and the tax rate is 25%. So the tax you need to pay is 250,000 pesos since it is 25% from that 1 million. After hiring PWD employees, let's say that PWD employee salaries is 1,500,000. And then the tax deduction to that 1,500,000 is 25%, which is 375,000 pesos. The new tax to pay is 250,000 minus the 25% tax deduction, which is 375,000 pesos. So it equals to negative 125. The 125, it is the refunded or excess outcome. Hiring PWD employees reduces the company's tax burden. And about the number 2 explanation of the incentives for hiring PWDs is it's like a reimbursement to the total cost of the improvements or modifications for PWD employees. The number 2 question is, what is bona fide occupational qualification or BFOQ? It says here that employment in particular jobs may not be limited to persons of a particular sex, religion, or national origin unless the employer can show that sex, religion, or national origin is an actual qualification for performing the job. The employer has the burden to prove the existence of a reasonable business necessity. It says there that regardless of sex, religion, or national origin, the employment in particular jobs should not be limited, not unless the employer can show that sex, religion, or national origin is an actual qualification for performing the job. Under bona fide occupational qualification, there is the thing we call permissible discrimination, also known as lawful discrimination, refers to situations where different treatment based on specific characteristics, age, sex, religion is allowed under the law. To give an example is the all-girls school. Since the institution clearly says it is all girls, we cannot accommodate boys to enter that school. Another example is acting and modeling because they require a specific characteristics when you go to acting or modeling. For example, marunong ka lang magluto and then nag-apply ka sa acting and modeling. Syempre, hindi ka nila kukunin since hindi mo naman alam mag-model, hindi mo rin naman alam mag-acting. The last example for that is if pilot ka po, and then your company says that if you reach the age of 60, you need to retire already for health purposes and also the safety of your passengers. We cannot call that a discrimination because the employers clearly show that the particular sex, religion, or national origin is an actual qualification for performing the job itself. The number 3 question is, what are prohibited acts against women workers? It shall be unlawful for an employer, number 1, to deny any woman employee the benefits. Number 2, to discharge any woman employed by him for the purpose of preventing such woman from enjoying the maternity leave, facilities, and other benefits. Number 3. Discharge a woman employee on account of her pregnancy or while on leave or in confinement due to her pregnancy. Number 4. To discharge or refuse the admission of a woman upon returning to her work for fear that she may again to be pregnant. Number 5. To discharge any woman or child or any other employee for having filed a complaint or having testified or being about to testify. Number 6. To require as a condition for or continuation of employment that a woman employee shall not get married or to stipulate expressly or lazily that upon getting married, woman employee shall be deemed resigned or separated. Or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of her marriage. Article 135 of Labor Code prohibits employers from discriminating against female employees based on their sex.
What is the rule on stipulation against marriage? It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tacitly upon getting married, a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate, or otherwise prejudice a woman employee merely by reason of marriage. This means that employers cannot require a woman not to get married as a condition for hiring or keeping her job. Dismissing or discriminating against women simply because she got married is illegal. For example, a company fires a female employee after learning she got married, claiming it violates a no marriage policy. This is not allowed under the law. What is the exception to the prohibition on stipulation against marriage? Dismissal based on this stipulation in the employment contract is a valid exercise of management prerogative. The prohibition against personal or marital relationships with employees of competitor companies upon its employees was held reasonable because relationship of that nature might compromise the interests of the company. In laying down the assailed company policy, the employer only aims to protect its interests against the possibility that a competitor company will gain access to its secrets and procedures. This means that an exception exists if the prohibition on marriage is linked to protecting the company's business interests, like preventing conflict of interest or maintaining confidentiality. For example, a company prohibits employees from being in a relationship with employees of a competing company, as it could risk leaking confidential information. What is discrimination against women under the Magna Carta of Women? Discrimination against women refers to: number 1. Any gender-based distinction, exclusion, or restriction which has the effect or purpose of impairing or nullifying recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedom in the political, economic, social, cultural, civil, or any other field. This means that treating women unfairly because of their gender, which affect their rights, freedom, or opportunities. For example, a company refusing to hire women for leadership roles simply because they are women. Number 2. Any act or omission, including by law, policy, administrative measure, or practice that directly or indirectly excludes or restricts women in the recognition and promotion of their rights and their access to and enjoyment of opportunities, benefits, or privileges. This means that any laws, rules, or practices that limit women's ability to enjoy their rights and opportunities. For example, a workplace policy that excludes women from certain benefits like parental leave available only to men. Number 3. A measure or practice of general if it fails to provide for mechanism to set or address sex or gender-based disadvantages or limitations of women as a result of which women are denied or restrict in the recognition and protection of their rights and in their access to and enjoyment of opportunities, benefits, or privileges, or women, more than men, are shown to have suffered the greater adverse effects of those measures or practices. This means that not providing ways to address or fix disadvantages faced by women, leading to unequal to opportunities. For example, a training program that only considered male applicants for career advancement without offering alternatives for women. Number 4. Discrimination compounded by or intersecting with other grounds, status or condition such as ethnicity, age, poverty, or religion shall be considered discriminations against women under Act RA number 9710, Chapter 2, Section 4. This means that discrimination worsened by other factors like ethnicity, age, or poverty. For example, a poor older woman being denied health care services because of both her gender and economic status.
What are the facilities for women under the Labor Code? The Secretary of Labor and Employment shall establish standards that will ensure the safety and health of women employees. This provision outlines the responsibilities of the Secretary of Labor in ensuring workplaces are safe and accommodating for women employees by establishing specific standards and regulations. In appropriate cases, he shall by regulations require any employer to 1. Provide seats proper for women and permit them to use such seats when they are free from work and during working hours, provided they can perform their duties in this position without detriment to efficiency. Employer must ensure that proper seats are available for women employees. Women should be allowed to sit when they are not actively working and also during their tasks if sitting does not negatively affect their efficiency. Example, in retail stores or assembly lines, employer can provide stools or chairs so female employee can sit when there are no customers or during breaks. Like, a cashier may use a high stool while performing her duties without compromising work efficiency. 2. To establish separate toilet rooms and lavatories for men and women and provide at least a dressing room for women. Employer must provide separate restroom and lavatories facilities for men and women to ensure privacy. Additionally, workplaces must provide at least one dressing room for women. Example, in a factory employing both men and women, there should be clearly designated men's and women restrooms. For women employees who need to change uniform or protective gear, a private dressing room should be available. 3. To establish a nursery in a workplace for the benefit of the women employees therein. Employer must set up a nursery or childcare facility for women employee when appropriate, recognizing their responsibilities as mothers. This is especially relevant in workplaces with many female employees or those industries where work hours are extensive. This is beneficial for the employee and employer since the employee can focus on her work and for employer will retain a talent worker. For example, in a corporate office with a significant number of female employees, a nursery could be established to support working mothers. This allows them to bring their young children to the workplace. 4. Determine appropriate minimum age and other standards for retirement and termination in special occupations such as those of flight attendants and the like, Labor Code Article 132. The Secretary of Labor must establish specific rules regarding the minimum age for certain jobs and the retirement or termination age for special occupations where health and safety are critical. For example, for flight attendants, the regulation may specify a minimum hiring age due to the physical and mental demands of the job. Firefighters, regulation may set a minimum hiring age due to the physical fitness required and the dangerous nature of the work. What is the classification of women working in a nightclubs, etc.? Any women who is permitted or suffered to work with or without compensation in any nightclubs, cocktail lounge, massage clinic, bar, or similar establishment under the effective control or supervision of the employer for a substantial period of time as determined by the Secretary of Labor and Employment shall be considered as an employee of such establishment for purpose of labor and social legislation. Note: no employer shall discriminate against such employees or in any manner reduce whatever benefits they are now enjoying by reason of the provision of this section. This specifies that women working in certain establishments are classified as employees under the effective control or supervision of their employers. They are entitled to labor and social legislation protections. This ensures that their rights as workers are not exploited and discriminated. This classification safeguards women in these industries, ensuring they receive a fair treatment and legal protection despite the nature of their work. Minors. Who is a child? A child refers to any person under 18 years of age. Examples: a 10-year-old student, a 15-year-old teenager living with their parents, a 5-year-old attending kindergarten. What is child labor? Child labor refers to any work or economic activity performed by a child that subjects him or her to any form of exploitation or is harmful to his or her health and safety or physical, mental, or psychological development. Child labor refers to any work or economic activity performed by a child that exploit them or harm their health, safety, and psychological development. For example, a child working in a factory for long hours leading to health issues. A child selling goods on the street instead of attending schools. A child working in agriculture with hazardous tools that may cause injury.
Who is a working child? Working child refers to when the child is below 18 years of age in work or economic activity that is not a child labor. When also the child is below 15 years of age in work where he or she is directly under the responsibility of his or her parents or legal guardian, and where only members of the child's family are employed or in the public entertainment or information. What is the role of employment of child below 15 years of age? The general rule is children below 15 years of age shall not be employed. But there is an exception. Number one, when the child works directly under the sole responsibility of his or her parents or legal guardian, where only members of his or her family are employed. Like for example, you have a family business where they can let their child work as long as the employees are also members of the family. And also, it must be provided that the employment does not endanger his or her life or safety or health and morals. And also, it doesn't impair the normal development of the child. And also, they must provide the child with the prescribed education that the child must attain. Number two is where the child's employment or participation in public entertainment or information through cinema, theater, radio, television, or other forms of media is essential. But there should be an employment contract that is concluded by the child's parents or the legal guardian with the express agreement of the child concerned, if possible. And also the added one is the approval of the Department of Labor and Employment. What are the hours of work of a working child? For a child below 15 years of age, they are allowed to work for not more than 20 hours per week, and they shall not exceed for 4 hours per day. And they are not allowed to work between 8 o'clock in the evening and 6 o'clock in the morning of the following day. And if the child is 15 years of age but they are below 18, they are not allowed to work for more than 8 hours. And also, they are not allowed to work between 10 o'clock in the evening and 6 o'clock in the morning of the following day. For example, those who are in the entertainment industries, those children who are acting, they are only given, most especially if they are below 15 years old, they are only given 4 hours to do the work or the acting that they are needed in the work. Because the tendency of that is 15 years old below are easily get tired. That is why they only set it as a rule that the child below 15 years of age are only given 4 hours to work in the industry or in the work that they are going to do. Who administers the income of the child? The salaries, the income, or the wages that the child earned shall be on her ownership and shall be primarily set aside for her support or for her education or for her future needs, and secondarily for the collective needs of her family. Additionally, the collective needs of the family shall not exceed more than 20% of the child's income. And also, the income of the child shall be administered by both parents. In the absence or incapacity of either of them, the other parent should administer the same. In case that both parents are absent or incapacitated, the other preference in parental authority as provided for under the family code shall apply. Rule on the child access to education. Every child shall have the access to formal and non-formal education. In all cases that the child is allowed to work, the employer shall provide the access to her primary or secondary education. There should be no employer that make a child work during school hours or hinder her to access education during school days. The continuing program for education and training for working child shall be that developed by the Department of Education for formal and non-formal, and the alternative learning system of education or by the TESDA, whichever is applicable to the circumstances of the child. Grounds and suspension of work permit. The regional director shall suspend or cancel the work permit issued to a working child. Number 1, if there is a fraud of misinterpretation in the application of work permit or of its supporting documents. Number 2, if the terms and conditions set forth on the child employment contract and employer's undertaking have been violated. Number 3, if the employer fails to institute measures to ensure protection, health, safety, moral, and normal development of the child. Number 4 is if the child or if the employers fail to formulate and implement a program for the education. And the last one is if the child has been deprived access to formal, non-formal, or else education. In conclusion, a child must not work. The role of a parent is to provide the basic needs of a child, to give them proper care, proper education, the basic needs that a child needs. But sometimes it is the worst form of the social injustice. They give birth when they cannot afford to give the basic needs that the child needs. Therefore, parents who lets their child seek money from the streets can be a form of child for labor or exploitation. It is very wrong that our parents, that sometimes the parents is the reason why the child work.
What are the hours of work of a working child? put it short, the Philippine Anti-Child Labor Act RA number 9231 sets strict limits on working hours for children. Children under 15 years old can work no more than 20 hours per week, with a maximum of 4 hours per day, while those between 15 and 18 years old are limited to 8 hours per day and 40 hours per week. Additionally, the law prohibits children under 15 from working between 8 p.m. and 6 a.m., and those between 15 and 18 from working between 10 p.m. and 6 a.m. This restriction aimed to protect children from exploitation and ensure their well-being by limiting their exposure to long working hours and night work. Who administers the working child's income? For further explanation, the Republic Act number 9231 states that a working child owns their earnings, which should be used primarily for their supports and education. No more than 20% of the child's income can be used for the family's collective needs. Both parents are responsible for managing the child's income, and their absence or incapacity. The order of preference for parental authority outlined in the Family Code applies. What is the role on the child's access to education? To put it concisely, the Philippine Anti-Child Labor Act RA number 9231 guarantees all working children the right to access both formal and non-formal education. This means employers must provide working children with access to at least elementary and secondary education, and cannot prevent them from attending school during their designated school hours. The Department of Education is responsible for developing implementing alternative education programs for working children, ensuring they have the opportunity to continue their education even while working.
Before we proceed to the next topic, which is the ground for suspension and cancellation of work permit, I would like to present first the Republic Act number 9231. Republic Act number 9231, an act providing for the elimination of the worst forms of child labor and affording stronger protection for the working child. Amending for this purpose, Republic Act number 7610, as amended, otherwise known as the Special Protection of Children Against Child Abuse, Exploitation and Discrimination Act 2008. RA number 9231, also known as the Anti-Child Labor Law, is a law in the Philippines that aims to eliminate the worst forms of child labor and protect working children. So let's move to the grounds for suspension and cancellation of work permit. The regional director shall suspend or cancel this work permit issued to a working child under the following instances. We have 5. So number 1 is if there is a fraud or misrepresentation in the application for work permit or any of its supporting documents. 2. If the terms and conditions set forth in the child's employment contract and or employer's undertaking have been violated. Number 3. If the employer fails to institute measures to ensure the protection, health, safety, morals, and normal development of the child as required in Section 7. Number 4. If the employer fails to formulate and implement a program for the education, training, and skills acquisition of the child. Or number 5. If a child has been deprived access to formal, non-formal, or ALS education. So let's continue to the next topic, which is Kasambahay. Domestic worker or Kasambahay. When we say domestic, it exists or occurring in particular country like the Philippines. Domestic worker is someone who performs work in a private household, providing direct and indirect care services. The Republic Act 10361 aims to protect the rights and promote the welfare of domestic workers, ensuring they have fair working conditions and are treated with dignity. According to Republic Act number 10361, otherwise known as the Domestic Workers Act or Batas Kasambahay, Article 1, Section 4, it says that domestic worker or kasambahay refers to any person engaged in domestic work within an employment relationship such as, but not limited to, the following general house help, nursemaid or yaya, cook, gardener, or laundry person, but shall exclude any person who performs domestic work only occasionally or sporadically and not on an occupational basis. The term shall not include children who are under foster family arrangement and are provided access to education and given allowance incidental to education, like for example, baon, transportation, school projects, and school activities. Take note that Rule 13 Section 1, Book 3 of the Labor Code provides that house helpers shall refer to persons, whether male or female, who render services in and about the employer's home and which services are usually necessary or desirable for maintenance and enjoyment thereof, and minister exclusively to the personal comfort and enjoyment of the employer's family. The definition cannot be interpreted to include house helper or laundry woman working in staff houses who attends to needs of the company's guests and other person availing of the facilities. The criterion is the personal comfort and enjoyment of the family of the employer. The more fact that the house helper is working within the premises of the business of the employer and in relation to or in connection with its businesses warrants the conclusion that said house helper is and should be considered as a regular employee of the employer.
What are the benefits and rights available to house helpers under the Batas Kasambahay? The rights and the privileges of a domestic worker or kasambahay are as follows. Number 1. Standard of treatment. The employer or any member of the household shall not subject domestic worker or kasambahay to any kind of abuse nor inflict any form of physical violence or harassment or any act tending to degrade the dignity of a domestic worker. Under the Republic Act number 10361, Section 5, the standard of treatment safeguards the dignity and well-being of domestic workers. This section emphasizes the prohibition against any form of abuse, violence, or harassment directed towards these individuals. Prohibition against abuse. The law explicitly states that employers and household members are strictly prohibited from subjecting domestic workers to any kind of abuse. This encompasses a broad range of harmful behaviors, including physical violence, for example, hitting, kicking, slapping, or any other form of physical assault, harassment, and acts tending to degrade dignity. This prohibition prohibits any action that diminishes the domestic worker's self-respect or social standing. Example including humiliating public reprimands, discriminatory treatments, or any behavior that undermines their sense of worth. Number 2. Social and other benefits. A domestic worker who has rendered at least 1 month of service shall be covered by the Social Security System, the Philippine Health Insurance Corporation, and the Home Development Mutual Fund, and shall be entitled to all the benefits in accordance with the pertinent provisions provided by law. This section mandates that domestic workers who have completed at least 1 month of service are entitled to coverage under the SSS, PhilHealth, and Pag-ibig. These provisions ensures that domestic workers have access to essential social protection benefits, promoting their well-being and financial security. Number 3. Broad lodging and medical attendance. The employers shall provide for the basic necessities of the domestic workers to include at least 3 adequate meals a day and humane sleeping arrangement that ensures safety. The employer shall provide appropriate rest and assistance to the domestic worker in case of illnesses and injuries sustained during service without loss of benefits. At no instance shall the employer withdraw or hold the abeyance the provision of the basic necessities as punishment or disciplinary action to the domestic worker. This section outlines the employer's responsibility to provide essential necessities and support to domestic workers, ensuring their well-being and safety. This section emphasizes the provision of basic necessities, appropriate rest, and medical assistance in case of illness or injury sustained during work. Number 4. Right to certificate to employment. The right to certificate of employment for domestic worker is outlined in Rule 4, Section 7 of the Implementing Rules and Regulations of Republic Act 10361. This right ensures that domestic workers receive a formal document acknowledging their employment history, which can be valuable for future employment opportunities and other purposes. Number 5. Guarantee of privacy. Respect for the privacy of domestic workers shall be guaranteed at all times and shall extend to all forms of communication and personal effects. This guarantee equally recognizes that the domestic worker is obliged to render satisfactory service at all times. Under this section, privacy for domestic workers establishes a clear framework for respecting their personal space, communication, and belonging, while acknowledging their obligation to provide satisfactory service. The law explicitly states that respect for the privacy of domestic worker shall be guaranteed at all times. This right extends to all forms of communication and personal effects. Number 6. Access to outside communication. The employer shall grant the domestic worker access to outside communication during free time, provided that in case of emergency, access to communication shall be granted during work time. Should the domestic worker make use of the employer's telephone or other communication facilities, the cost shall be borne by the domestic worker unless such charges are waived by the employer. Under this section, access to outside communication ensures that domestic workers can stay connected with their families, friends, and support networks, promoting their well-being and mitigating potential isolation. Number 7. The domestic worker shall be entitled to all other benefits under existing laws. Number 7 is already explained in number 2, Section 30. Number 8. Weekly rest period. The domestic worker shall be entitled to at least 24 consecutive hours of rest in a week. The employer and the domestic worker shall agree in writing on the schedule of the weekly rest day of the domestic worker, provided that the employer shall respect the preference of the domestic worker as to the weekly rest day when such preference is based on religious grounds. Nothing in this provision shall deprive the domestic worker and employer from agreeing to the following: A. Offsetting a day of absence with a particular rest day. B. Waiving a particular rest day in return for an equivalent daily rate of pay. C. Accumulating rest days not exceeding 5 days. Or D. Other similar arrangements. This section ensuring the domestic workers have time to rest, recharge, and attend to personal matters. These sections outline the minimum rest period, the process for scheduling rest days, and the flexibility allowed for both employers and the domestic workers in managing their schedules. 9. Assignment to non-household work. No domestic worker shall be assigned to work in a commercial, industrial, or agricultural enterprise at a wage rate lower than the provided for agricultural or non-agricultural workers. In such cases, the domestic worker shall be paid the applicable minimum wage. This section addresses the situation where a domestic worker is assigned to work outside of their usual household duties, specifically in a commercial, industrial, or agricultural enterprise. This section aims to protect domestic workers from being exploited by employers who might attempt to assign them to different work environments while paying them a lower wage than what is standard for those jobs. 10. Leave benefits. A domestic worker who has rendered at least 1 year of service shall be entitled to an annual service incentive leave of 5 days with pay, provided that any unused portion of said annual leave shall not be cumulative or carried over to the succeeding years. Unused leave shall not be convertible to cash. This section establishes the service incentive leave benefits for domestic workers, providing them with a paid leave entitlement after completing a year of service. This section outlines the eligibility criteria, duration, and specific condition regarding the unused and non-convertibility of unused service incentive leave. 11. Right to terminate the employment. The right to terminate employment for both domestic workers and employers is outlined in the implementing rules and regulations of Republic Act number 10361. This section addresses the termination of employment, providing guidelines for both parties involved. Grounds for termination. Just causes. The law recognizes just causes for termination, which are acts attributable to domestic workers' own wrongful action or negligence. This includes serious misconduct, gross and habitual neglect of duties, fraud or breach of trust, commission of a crime, and other similar causes. The law also allows for termination based on authorized causes, which are lawful grounds not arising from the domestic worker's fault. These include closure or cessation of operations, redundancy, retrenchment, and disease. Number 12. Right to education and training. The employer shall afford the domestic worker the opportunity to finish basic education and may allow access to alternative learning system and, as far as practicable, higher education or technical and vocational training. The employer shall adjust the work schedule of the domestic worker to allow such access to education or training without hampering the service required by the employer. This section recognizes the fundamental right of domestic workers to education and training, aiming to empower them to improve their skills and opportunities for advancement. This section outlines the employer's responsibility to provide access to education and training, adjust work schedules, and accommodate these pursuits and encouragement personal development. Number 13. Right to be provided a copy of the employment contract. The right to be provided a copy of the employment contract is a crucial aspect of domestic workers. This right is enshrined in Rule 4, Section 1 of the Implementing Rules and Regulations, ensuring that domestic workers have a clear understanding of their employment terms and conditions. This section mandates that an employment contract be executed between the domestic worker and the employer before the commencement of service. This contract must be written in a language or dialect understood by both parties. This section specifically states that the domestic worker shall be provided a copy of the duly signed employment contract. This ensures that the worker has a tangible record of the agreed upon terms and conditions. 14. Rescue and rehabilitation of abused domestic workers. Any abused or exploited domestic workers shall be immediately rescued by a municipal or city social welfare officer or a social welfare officer from the Department of Social Welfare and Development, in coordination with the concerned barangay officials. The DSWD and the DILG shall develop a standard operating procedure for the rescue and rehabilitation of abused domestic workers, and in coordination with the DOLE for possible subsequent job placement. Under this section, it establishes a comprehensive framework for the rescue and rehabilitation of abused or exploited domestic workers. This emphasizes immediate intervention, coordinated efforts between government agencies, and the provision of support services to ensure the well-being and reintegration of victims. 15. Right to exercise their own religious beliefs and cultural practices. The right to exercise one's religious beliefs and cultural practices is a fundamental human right and is explicitly protected for domestic workers under the Domestic Workers Act and its implementing rules and regulations. While Rule 4, Section 1 of the Implementing Rules and Regulation doesn't explicitly mention this right, it is implied through the border principle of the law and the recognition of the worker's dignity and autonomy. It implied protection of religious freedom, like respect for human dignity, non-discrimination, and freedom of conscience. Number 16. Prohibition against disclosure of privileged information. All communication and information pertaining to the employer or member of the household shall be treated as privileged and confidential, and shall not be publicly disclosed by the domestic worker during and after employment. Such privileged information shall be inadmissible in evidence except when the suits involve the employer or any member of the household in a crime against persons, property, personal liberty, security, and chastity. This section addresses the sensitive issue of confidential and the protection of privileged information within the employer-domestic worker relationship. This section aims to balance the worker's right to freedom of expression with the need to safeguard the privacy and security of the employer and their household. Number 17. Daily rest period. The domestic worker shall be entitled to an aggregate daily rest period of 8 hours per day. This section guarantees a fundamental right of domestic workers, the right to a daily rest period. This section ensures that domestic workers, despite the unique nature of their work, are entitled to a minimum of 8 hours of uninterrupted rest each day. 18. The right to rest. 8 hours of rest. The law explicitly states that a domestic worker shall be entitled to an aggregate daily rest period of 8 hours per day. This means that the worker must be free for any work-related duties or responsibilities for at least 8 consecutive hours. Uninterrupted rest. The 8-hour rest period shall be uninterrupted, meaning that the domestic worker cannot be called upon to perform any task or be disrupted during this time. Number 19. Minimum wage. The Domestic Workers Act and its implementing rules and regulations establish minimum wage rates for domestic workers, recognizing their essential role in society and ensuring they receive fair compensation for their labor. This section outlines the specific minimum wage rates based on the location of employment.
Who bears the cost for the premium payments of the Kasambahay to SSS, PhilHealth, or Pag-ibig? Premium payments or contributions shall be shouldered by the employer. However, if the domestic worker is receiving a wage of 5,000 pesos and above per month, the domestic worker shall pay the proportionate share in the premium payments or contributions as provided by law. Employers are responsible for paying the premiums or contributions to the Social Security System or SSS, PhilHealth, and Pag-ibig for their kasambahays. This means they must cover the cost of these essential benefits to support the domestic workers' Social Security, health insurance, and housing fund. In the shared contributions, if a kasambahay earns 5,000 pesos or more per month, they must share in paying these contributions. This means that part of their salary will go towards these benefits, similar to how other employees contribute to their benefits. So to further explain that, for those working in the National Capital Region, the minimum wage is set at 5,000 pesos per month. This amount ensures that domestic workers in the capital have a baseline income to meet their living expenses. And in the chartered cities and first-class municipalities, in these areas, the minimum wage ranges from 2,500 pesos to 4,000 per month. The range depends on the specific city's classification and economic status. On the other municipalities, For those employed in other municipalities, the minimum wage is between 1,800 pesos and 3,000 pesos per month. The variation considers the differing cost of living in various regions. What is the minimum wage of a kasambahay? The minimum wage of a kasambahay as of December 2017 shall not be less than the following. Number 1, 5,000 pesos a month for those employed in the National Capital Region or NCR. As of January 2, 2020, wage order number NCR-DW02, Section 1. Number 2, 2,500 pesos to 4,000 pesos a month for those employed in the chartered cities and first-class municipalities. Number 3, 1,800 pesos to 3,000 pesos a month for those employed in another municipalities. 2019 Handbook on Workers' Statutory Benefits. To elaborate that, employers must pay the wages on time directly to the kasambahay and in cash at least once a month. This ensures that domestic workers receive their salary regularly and can manage their finance effectively. And employers cannot make deductions from the kasambahay's wages unless these deductions are required by law like SSS, PhilHealth, and Pag-ibig, or the kasambahay has agreed to it in writing. This protects the worker's income from unauthorized reductions. What is the rule for the payment of wages of a kasambahay? Payment of wages shall be made on time directly to the domestic worker to whom they are due in cash at least once a month. The employer, unless allowed by the domestic worker through a written consent, shall make no deductions from the wages other than which is mandated by law. No employer shall pay the wages of a domestic workers by means of promissory notes, vouchers, coupons, tokens, tickets, cheats, or any object other than cash wages provided for under this act. The domestic worker is entitled to a 13th month pay as provided for law or the Republic Act number 10361, Article 4, Section 25. Also, employers are prohibited from paying wages using promissory notes, vouchers, or other non-cash items. Kasambahay must receive their salaries in cash to ensure they have immediate access to their earnings. And kasambahays are also entitled to a 13th month pay, which means they receive an additional month's salary at the end of the year, providing them with extra financial support. And also, employers are prohibited from paying wages using promissory notes, vouchers, or other than non-cash items. Kasambahay must receive their salaries in cash to ensure they have immediate access to their earnings. And kasambahays are also entitled to a 13th month pay, which means they receive an additional month's salary at the end of the year, providing them with extra financial support. And in the deductions part, deduction from the kasambahay's wages are only allowed if they are mandated by law, such as contributions to SSS, PhilHealth, and Pag-ibig. This ensures that deductions are only made for legitimate purposes. And any other deductions required the kasambahay's written consent. This agreement ensures transparency and that worker is fully aware of and agrees to the salary deductions from their salary. By understanding these points, both employers and kasambahays can ensure that employment conditions are fair and compliant with the law. This knowledge helps protect the rights and welfare of domestic workers while promoting a respectful and supportive work environment. And in the deduction part, deductions from the Kasambahays wages are only allowed if they are mandated by law, such as contributions to SSS, PhilHealth, and Pag-ibig. This only ensures that deductions are only made for legitimate purposes. Any other deductions require the Kasambahay's written consent. This agreement ensures transparency and the workers is fully aware of and agrees to the deductions from their salary. By understanding these points, both employers and kasambahays can ensure that employment conditions are fair and compliant with the law. This knowledge helps protect the rights and welfare of domestic workers while promoting a respectful and supportive work environment.